Okay. Hello, Jim. Hello,
Hi.
everybody. My name is Tila Chalmers, and I'm the CEO of the Alameda County Bar. And I have the pleasure today to be speaking with Jim Brosnahan, who is a man of many interesting backgrounds, but among other things, has been a partner at Morrison and Foerster for many years and a well-known constitutional law attorney. So, Jim, let's just start by having you sort of outline for us your career path.
Well, I practiced law, trial law, for 60 years. I started as a federal prosecutor, and I did that job in Phoenix and then San Francisco for 5 years. And then I defended civil and criminal cases for many, many years. Enjoyed it. I figured out that I was in trial the equivalent of 12 full years.
Wow.
And part of that was the way it was when I started, because there were just a lot of trials for a long time. There were a lot of trials. One year I was in trial the whole year in two different cases in two different states. So I had a very enjoyable career trying cases. I was at Morrison Forrester for I've been there 45 years. I'm still there as of counsel. And that was has been a wonderful experience for me because I really believe Morrison is a law firm with a soul. And the soul involves pro bono work. It involves the fulfillment of the lawyers who are there by what they're interested in, what they want to do. And so that's been a great experience with a tremendous number of lawyers, which grew over the years as we expanded, because we went from a fairly small firm to, as we say modestly, worldwide.
I believe I've seen a T-shirt that says "The sun never sets on the Morrison Empire," isn't it?
Oh, we got yeah, whatever. We got T-shirts like you wouldn't believe.
Um, so, when you were a federal prosecutor, what kinds of cases were you handling?
I tried all kinds of cases because I started in Phoenix and we had jurisdiction over the Native American jurisdictions, the Pimas, the Apaches, the Navajos. And I spent a lot of time on the reservations, which as a young man coming from Boston, was my original home where I grew up, was a very exciting, exotic thing to do. I had murder cases, plural, manslaughter, those kinds of things. Then we had a lot of real estate fraud cases
Hmm.
in Phoenix. Phoenix was always expanding, and fraud people were arriving and taking people's money and all that kind of thing. I tried a number of tax cases, which I wouldn't think I would have enjoyed, but I love to put together the parts of a criminal tax case and accounting. I was interested in that. So I was always interested in just about any kind of trial. The only dull trials that I handled were narcotics cases, which are very dull. Are you the police officer? Yes. Is this narcotics? Yes. Where did you get it? I got it from the defendant. Okay, thanks very much. Ladies and gentlemen of the jury, we can't have this going on. That's okay. So it was interesting. I remember cross-examining one young man on a theft of automobile case. I had to try the case twice. We had a hung jury, and they convicted him the second time. And as he was walking down the hall, he leaned over to me and he said, very respectfully, he said, "Mr. Brosnahan, your cross-examination was much better this time." So you never knew on any given day you go into the office, you never knew what was going to happen. The phone would ring, and I loved that the action of it. There was a lot of action to the job.
And I would imagine that would have changed when you moved over to Morrison. That's a different pace of law practice.
Yes, and I was with another firm for 9 years actually before Morrison. But yeah, it was interesting in a different way. It was probably more intellectual. The briefs involved very complex kinds of issues, whether it be in more recent years, patent cases, or again, in the early days, I did a lot of civil fraud cases. I did criminal cases. I defended two men who were accused of stealing poverty money. They had a poverty program, but they had actually spent it feeding people in Oakland. And so I learned that's the exciting part about trial work, what it is you're learning. I spent a lot of time, we put on 29 witnesses, all of whom had gotten food from this food bank that they had started with the federal money. And the jury, they didn't acquit, but they had a hung jury 10-2, and then the government dropped the case. So I'd count that as a win. But I was learning, I, I've always relished the idea that I could go to Morgan Stanley in my best suit in New York City and chat with the financial people, and then go to Oakland and talk to the people who needed food. And it was that diversity, I think, that kept me going.
And so, when did you first start taking more constitutional law cases?
Well, of course, criminal law has a lot of constitutional cases. I mean, you have the Fourth Amendment a lot, and so that was really the beginning of it. I'd be asked to take a case, like on the constitutional case. I argued two cases in the U.S. Supreme Court. Both of them were constitutional cases, and it's interesting. You get the idea after you try cases for a lot of years. You get the idea that you can get into anything. And that's a very useful state of mind. It works for hobbies. If you decide to have a hobby, you just think if you're a trial lawyer, well, I'll just go and I'll learn about how to do it and I'll get better and as I go along. So that's what I did. I wrote. I've always written 2, 3, 4 articles a year on something, and a number of those were on the Constitution, various issues that interested me. Right to counsel has always been a great interest that I've had, and diversity. Those two things I think are at the heart, as you well know, because you've done a lot of great work on those things, is at the heart of the conscience of the organized bar. You got to open the doors to make sure people come in from all the communities. And when they do, they change the approach because they come, when women came in large numbers in the 70s, they brought with them their concerns. Some of them had knowledge about abuses and things of that kind. And so all of a sudden, there was a great interest in child abuse and spousal abuse. And before that, I can testify, there'd been almost none of that. So that's a good reason to open the doors of the profession. And I see at the moment, there's a resolution, an initiative, I hope it passes, that would allow various factors to be considered when people are admitted to law schools. I'm of the view that we have yet in law schools to master who's going to be a good lawyer or not. It's more complicated than a piece of paper and some answers. A lot more complicated.
And what are some of the things you think make for a good lawyer, if you could only spot them early enough?
Well, I'd say hard work is good. Hard work, but empathy with clients. Empathy, I found out not that long ago, is something in the brain. There's a part of the brain that takes care of empathy. And a lot of the work lawyers do aren't just limited to the case, but trying to get the client through very difficult times. I've spent a lot of time in holding cells, talking to people who faced enormous danger of one kind or another, um, and focusing on their needs. It's very simple, really.
Hmm.
It's really, once you get it, it's easy in a way to be um, as much help as you can to people going through tough times. Divorces, I did divorces, and people were miserable and all that kind of thing. It's very hard to mention a case, the kind of case that I didn't do.
Hmm.
I did. I handled about 20 patent cases,
Well,
among other things, and only one of them was dull. It was very dull. It was these two pieces of equipment that shook things to test them or something. I mastered it in about a half an hour, and that was dull. Everything else, reprogrammable computer chips. I tried that case. So it's all been a wonderful learning experience. That's that's the part personally that I get the most out of.
I can imagine one of the most challenging things in cases like that is you've taken this time to learn what a reprogrammable computer chip is, but how do you convey that to the jury within the
Well,
context?
exactly the right question. You have this body of facts. It's just as complex as you want it to be, and you have to boil it down and get it to a more simple and true statement of what the difference is. And then you have a chart or two charts or three charts. And you learn how to put those charts together like they were very simple. They really go right at it. It's true. The sophisticated people sometimes denigrate that ability, but that's what trial lawyers do. You have to boil it down and get to the essentials. And after a while, you do that pretty fast.
I bet. Let's talk about that famous case you had defending the man who was sometimes referred to as the American Taliban.
Mhm.
How did you come to get that case, and tell us a little about it?
Well, he was arrested. He was found in Afghanistan, and he was from Marin County. And his father had seen me at a meeting. His father was with PG&E, and I was. They were suing my client. And so I went to a meeting, and they said they wanted $3 billion. And I said it would be malpractice for me to stay in this room another minute. And very dramatic, very Irish. I closed the book and I stomped out. Well, something about that, I guess, told Frank that his son might be okay with me. And so he called me up and he came in, told me about it. And we went back to Virginia, where our client was, and I met him. And he was not anything like what the federal government was calling him. Everybody in the whole world had decided that he was just a terrible person. It was really not true. It was very interesting. I wouldn't have missed it for the world. We had death threats, we had bodyguards. Screw them. You know what I mean? I mean, one guy called me up. I thought he was a lawyer, but he called me up and he said, my group is deciding what to do about you. It was a threat. And I said to him, look, I've got the best investigator in the world. You need to know I can find out exactly where you are. And when I do, I'll appear in your office and you won't like it. Don't ever call here again. It's a mistake to threaten an Irish American. It's a big mistake. We know how to handle these people.
All right.
Or we
Um,
think we do.
let's, which is almost as good. Let's talk about the right to counsel, because you really were instrumental in the passage of the ordinance in San Francisco that has brought us the right to counsel in eviction cases. How did your commitment to that topic start?
Well, I won't cover the whole thing, but it actually started in 1962 when I was a prosecutor. I was prosecuting a murder case. And in those days, they had a system whereby the judge would ask a civil lawyer who was sitting there waiting for the civil calendar to come up and represent the defendant. Well, the defendant was charged with first-degree murder, and up came a young man who was probably 27 years old. And I thought, I was 28 and he was 27. So I thought, he's too young to do this. So I went into the judge and I said, maybe you'd appoint a second lawyer to be two lawyers. I was full of myself, I suppose. And the judge said he would do it. But when he brought it up with this lawyer, the lawyer bristled. He said, no, I can do it. Well, it turned out he did a really good job. But I bought a book at that point, it's 1962, on the right to counsel, because I thought this is wrong. I mean, this is the most important kind of a case, in my opinion, in the whole legal world. It's a death penalty case. And so I got interested in it then, and all the way through. And when I was president of the San Francisco bar, that was certainly one of my two issues. Diversity was the other one. Diversity I worked on a little bit in college at Boston College. I'm kind of an outsider, really. That's the way I think of myself. I just identify with people who have problems or whatever, or don't have money. My Irish grandparents had no money in the Depression. I used to spend my summers with them. They shielded me from all that, but they didn't have any money. So that's how I got interested in it. And I've stayed interested in it. I'm working on it now a little bit. And it's a worthwhile project, but it's very frustrating because there are powers within the country that make it their business to make sure there's a reduction of lawyers, especially if their clients can, for example, foreclose more easily if there's no lawyer on the other side. It has a sinister aspect to it. But anyway, there's a lot to it, and it's important.
So it's interesting to me that you stuck with it. I mean, your first engagement with the issue was before Gideon v. Wainwright, right?
About a year.
Yeah, but
Yeah.
you continued to be interested in it with respect to the civil arena, where we certainly don't have anything close to that.
I did, and we also worked on making sure the criminal, particularly the public defenders in San Francisco, had the resources they needed. There was a case we brought where they had two telephones in the whole office of the DA's office, and we decided that two telephones was a denial of due process or something, and we filed an action. We had a trial. We had a trial involving whether they had enough to do the job. And the judge, Judge Wallenberg, the son, filed an order in which he said, they need more money. So that was good.
Very interesting. You mentioned that you were the president of the San Francisco bar, and while you were there, you were you founded the what was then called Volunteer Legal Services Program.
Yeah.
So that obviously has great resonance.
Well, it was a good thing, but it took an awful lot of people to organize that. There had always been pro bono. It wasn't like I invented pro bono. I didn't. There's always been a lot of it. And but what we did is we structured it. I think you want to get something done, you got to have a structure. And we hired a person to be the executive director. That was the first person in that organization. Now they have a large number of people,
Large number, yeah.
which is great. And they do wonderful service over there. So it's expanded a whole lot. Drew Ramey, as you know, has been a stem winding, idealistic, unbelievable, irrepressible force for good. And so that, that was good. That was good. Everybody committed to spend 5% of their time doing pro bono. I think that was the first bar in the country that I know of that did that. Later, the ABA did it because my partner Bob Raven did it at the ABA.
And have you seen that the pro bono culture blossom at MoFo in particular?
Yes, because I mean, for a lot of reasons, but part of it was supported by the top lawyers. That's the key. I mean, if you see a senior person taking a pro bono case, then and you're a young lawyer, you can take one and feel okay about it. And we've always done the pro bono there, and we've had some very interesting cases. Over the years, I started to make a joke that I had to take credit for things I didn't know anything about. And that was the job of a senior partner. Like I was at a cocktail party in Los Angeles and a lady came up to me and she said, "Oh, what you did with that Argentinian general, that was fantastic." And I thought, yes, of course it was. Who's this? And so, but it has the pro bono part of the firm is active all over the firm. I think we have something like 15 offices in several countries and so, sort of thing.
So I'd love to hear about some of your favorite cases that you've taken to trial over the years.
Yeah, as I say, I like all the cases. I think being an Irish American, I enjoyed greatly a case for a man who had escaped from the Maze prison in Northern Ireland. And I made 6 trips to Northern Ireland, got to know a lot of lawyers over there, got to know it very well, and tried a case before Judge Legg for a month. And Judge Legg ruled against us, but we went to the Ninth Circuit. It was an extradition trial. And the Ninth Circuit said should get a new trial. At that point, the peace process had kicked in. So we were informed that the British government would no longer seek the extradition. And in the course of that trial, we proved, although it didn't change Judge Legg's ruling. Judge Legg's a very good judge, was a very good judge, but it didn't change him. But we showed that the officers in Belfast had altered their notes, which is a very serious matter, is a matter of Northern Irish procedure. And he wasn't impressed with it. But I'm happy to tell you that that evidence was presented by solicitors and barristers in Belfast High Court, and that 2.5 months ago, the judges held that my client's conviction for murder was unsound. Wow. Based on that evidence. So in other words, there is no conviction of murder. So that was good. I represented, now that you brought up this idea of cases I might have lost, I tried for 6 months the case of a Mexican widow who lived in Nogales, and she was helping people from Central America in the 1980s. And she was acquitted of 3 counts, but she was convicted of 2. But then she got probation, so it was a sort of a win. But that spending time with those church workers, Presbyterian minister, a Catholic priest who was indicted for giving a hamburger to a Central American refugee. They were good people, and they were living the Bible in the right way. Wasn't ideology, it was just help the people.
Right.
That was it.
And we should articulate, these people were being charged with harboring fugitives in essence?
Transporting undocumented people. That was one of the big charges, but they were rather careful. They didn't walk people across. They would stop on the Mexican side, usually on the Mexican side. But then somebody would take them in on the American side. A number of the people were entitled to make their claim that they would be prosecuted at home. And so that was part of the case. But I spent a lot of time in Mexico, which I learned a lot about Mexico. They're still upset down there about us taking California. They still, in terms of perspective, they're really not happy about that. And so I learned a lot about the culture and the people. And my client really was an unassuming, very nice, saintly sort of person. 5 children, and just 60 years old. It was very enlightening, actually. So that was good.
And tell us a little bit about arguing at the Supreme Court. What was that like for you?
Yeah, well, I argued twice, and the first time I had a really hard criminal case, and we lost 7-2. And the agents had surreptitiously recorded my client in violation of regulations, which said you're not supposed to do that. But we lost that. It was the Burger Court, and they were, so then Rehnquist was on the court. I had known him in Phoenix. 3 years later, I testified in the Senate against Rehnquist, confirmation as Chief Justice. And it was, without making a big deal out of it, it was the right thing to do. He had been challenging voters in the 1962 election. Wow. And which was fine with me. I mean, that was a long time ago, except he had denied it. He said he never did it. Well, he did. So I testified against it. Then about 7 years later, I argued my second case, and Rehnquist was, of course, sitting on the court as the Chief Justice. So now I'm going to go back and argue in front of Rehnquist. This is exciting, and I didn't know what to expect. My case was last, and when they called my case, he got up. He was a large man. I always kind of liked him. He had a dry wit and a kind of a 15th century sort of approach to government. And he got up and he turned and he walked through the black curtains and he was gone, leaving 8 justices there. So I argued we won a unanimous opinion for the Democratic Central Committee in San Francisco and other political committees on the grounds that the legislature had forbidden them from endorsing candidates. That's a violation of the First Amendment. So it was a First Amendment right of assembly case. And it's cited from time to time versus Democratic Central Committee versus EU. She was the Secretary of State.
Huh. Well, Jim, as we wrap up here, I want to ask if you have any words of advice, particularly for newer attorneys who are trying to make their way in this challenging environment.
Yeah, I talk to a lot of young lawyers. I talked to one last week. Anybody who asks me, I will talk to them. You have to just keep going. And as I tell my students at Berkeley Law, you have to get a mentor. And the mentor it has to work. You must have a mentor who cares about your career. It's not that easy. If you don't have a mentor and you can't get a mentor in that firm for whatever reason, you need to go somewhere else. It's that in the first 7 years, it's crucial to get a mentor and know that you have somebody that's looking out for you because you need that. When I started, I suddenly realized I had no idea how to try a case. I mean, I just didn't have a clue. And my first trial was a first degree murder case. That was my first trial. Hello, oh my God. So, and you just keep learning and you keep going, um, keep keep plugging at it, working, learning, and I. This may sound very old fashioned, but I did specialize in a lot of things, 25 different things. But don't be afraid to try something new, you know, because it keeps your interest up. And I would always say, and you'll appreciate this, go over to the Bar Association, join a couple of committees that you care about, because you'll meet the best people. You'll really meet some good people, and you'll learn, and that'll be good. Just don't ever give up.
That's great advice. Thank you, Jim. And that's part of what I think bar associations are doing now, uh, is providing mentors, opportunities to connect with mentors.
Which is a wonderful program. That's great.
Yeah. Well,
Yep.
Jim, thank you so much for spending the time. I really appreciate it. It's been
Thanks
great
for
hearing
having
your
me.
stories.
Thank you. Very nice.
All right. Take care.
Okay. Okay.